Good afternoon, everyone. I hope you all had a good lunch. I've been hearing about the lentils. Your postprandial treat is a talk on professional negligence claims against accountants, where the claimants seek damages for trading losses. This is our attempt to try to find an analytical framework that we can use to guide us in working out when trading losses are recoverable from accountants and when they are not. As you can hear from my voice, my search for coherence may already be over. Happily, you'll hear from my colleagues Anthony Jones and Pippa Manby, whose voices and intellects are more penetrating than my own. In terms of the structure of our talk, I'm going to spend a few minutes introducing the nature of trading loss claims and what analytical problems arise with them. Anthony will then take us in detail through two very important decisions in this area, Galoo and, of course, Manchester Building Society, to see if they offer a basis for a coherent legal analysis of trading claims. Next, Pippa will look at some particular issues arising where there is collusive management fraud within the entity that is the subject of the audit. And then I will come back and seek to draw the strands together, touching also upon the topics of reliance and legal causation. So, introducing trading loss claims. What are they? Now, we're going to keep it simple for today's purposes and focus exclusively upon claims brought by or on behalf of clients. So there are no duty of care issues that we need to wrestle with. And where one element of the head of loss is that after the audit, the company trades in a loss-making way. So the essence of the claim is as follows. On breach, that the audit was carried out negligently, the clean opinion should not have been given, but should have been qualified in some way or another. And then on causation, had the opinion been different, the company's trading would have been brought to a halt. Now, just on that last point, the common suggestion by claimant companies, usually via their liquidators, is that the company would have been wound up earlier. But it may also be the case, as it was in AssetCo, that the contention is that the loss-making activities or attitudes within the company would have been remedied, such that the future trading would have been not loss-making at all. Now, keep in mind that loss-making can involve both spending money and incurring liabilities. So, introducing then the analytical problems arising from trading loss claims, the first is not so much an analytical problem, but a feature, which is that they are big money claims. So the famous Cambridge credit case, there were 170 million Australian dollars in issue, and that was in 1971. The second problem, or feature, is that the cases themselves, the reports, are extremely lengthy, but often in the recitation of the facts, and rather less in the legal analysis of the principles at play. Relatively few decisions come after trial, as distinct from usually unsuccessful strikeout applications. And there's been no real opportunity, so far as we've been able to find, and hopefully we're right, for judges to bring into play the Manchester Building Society analysis. And thirdly, they are claims that tend to invite two extremes of analysis. On the one hand, it might be said that trading losses arise from companies being in existence and trading. And so why should auditors, accountants be responsible for that? The other extreme is the but-for analysis, which is if it can be said that but for the negligent auditing, the trading wouldn't have taken place, then why is it not the case that all those losses should be recoverable? Now, to us, as a matter of legal instinct, both those extremes seem to be wrong. A sensible starting point, then, in a search for coherence is the English case that is commonly said to be authority for upholding the first principle and rejecting the second. That is to say, the case of Galoo and Bright Graham Murray. And happily, Anthony will take it from here.
Thanks very much, Jamie. So the decision in Galoo regarding the non-recoverability of trading losses was founded upon a decision of the New South Wales Court of Appeal called Alexander and Cambridge Credit from 1987. In Alexander, on appeal, the trial judge's award of damages against the auditor was reversed by a majority, and the claim was dismissed. The majority judgments in the Court of Appeal of New South Wales did not speak with one voice, but they all found a but-for test insufficient. Now, Justice of Appeal McHugh focused on what he called common sense, saying that the auditor's negligence had been so superseded by supervening events that it should no longer be treated as a legal cause. Justice of Appeal Marnie found that allowing a company to remain in existence does not cause losses from dangers incidental to mere existence. This turns into a phrase that they keep coming back to, mere existence. And he used a homely example. If a defendant promises to direct me where I should go at a crossroads, and he directs me to the left road rather than the right, what happens to me on the left road is, in a sense, the result of what the defendant has done, but not everything which is a result in the broad sense should be accepted as a result for the purposes of the law. If, being on the left road, I slip and fall, the fact alone that it was the defendant's direction which put me there will not without more make the defendant liable for my broken leg. Now that might seem common sense enough, but of course different people disagree on what is and what is not common sense. And this is indicated by the minority judge, Justice of Appeal Glass, who said he too was applying common sense but came to the opposite conclusion of finding the auditor liable. He used a similarly supposedly common sense example. He said, if an unseaworthy vessel puts to sea because marine surveyors have negligently certified it, its loss will be due to the marine its loss will be due to the marine hazards which cause it to founder, but it's equally true that its loss could not have occurred but for the fact that it put to sea as a result of the negligent survey. So what we have is people applying not very rigorous analysis and coming up with different answers. The same situation arose in this jurisdiction in Galoo. The claimant's case on the facts was no more and no less than, had the auditor's report been non-negligent, the company would not have carried on trading, and so the trading losses were recoverable from the auditors. The claimant did not seek to link this in any way to the content of the negligent report, with precise reasons why the trading had carried on. And it's a bit of a hallmark of these cases that claimants tend not to plead out in any particularity precisely which bit of the report led to the trading. So it was that in Galoo, Ronald Walker QC struck out the trading loss claims. The Court of Appeal agreed. They referred to the need to establish that the auditor's report was a dominant or effective cause of the trading losses, as some super-added requirement to but-for causation. And they held, as an application of common sense, that phrase again, that the report was merely the occasion for the trading losses, the mere incident, equivalent to what Justice of Appeal Marnie said in Alexander. Now, if we pause at this point, Alexander and Galoo may be seen to be insubstantial foundations for any form of blanket proposition that trading losses are not recoverable from auditors. And perhaps it's a disloyal thing to say as a Sydney-sider, but things coming out of New South Wales often appear superficially substantial, but lack something on further analysis. These cases don't really lay down an absolute rule about trading losses at all, we think. The most that can be said is trading losses are not recoverable if the claimant has been unable to demonstrate a causal link between negligent features of the report and the characteristics of the ongoing trading that have led to the trading being loss-making. And as an aspect of that, trading losses are not recoverable if the decision-making body of the company is unable to explain how a differently worded report would have given them relevant knowledge about the company that they did not already have, and where that knowledge may be connected to the ongoing loss-making trading. So we suggest that Galoo may be said to be authority for rejection of a strict but-for model, but on the other hand, it can't be said to be authority for the universal application of the mere existence model. So, in a search for coherence, we have to reject two extremes. And what principles then can we employ to try to find something in between that seeks to pick up the Galoo themes of causal linkage, knowledge, and relevant reliance? We can potentially work with two cases of highest authority, namely MBS from the Supreme Court and Capro and Dickman from the House of Lords. We can recall the six-part test in MBS, and if we assume for the moment that factual causation is established, then items 2 and 5 in the Manchester Building Society list demand a focus on the scope of the auditor's duty. So, step 2, what are the risks of harm to the claimant against which the law imposes on the defendant a duty to take care? That's the scope of duty question. And step 5, is there a sufficient nexus between a particular element of the harm for which the claimant seeks damages and the scope of duty? So that's the duty nexus question. And as we know, as Lord Hodge and Lord Sales told us in Manchester Building Society, the key inquiry is as to the purpose of the duty, judged on an objective basis by reference to the reason why the advice is being given. Now, thankfully, we have firm foundation for the answer to the key inquiry, because the House of Lords in Capro and Dickman actually said the purpose of an audit process is to enable the shareholders to scrutinise the conduct of the company's affairs and to exercise their collective powers to reward or control or remove those to whom that conduct has been confided. So we now have some form of analytical basis to put forward a coherent theory. If we ask ourselves whether there should be a blanket prohibition on recovery of trading losses from auditors, the clear answer should be no. That's because the purpose of the auditor's report is intimately linked with the ongoing good financial management of the company. If the company is financially mismanaged in a period after the audit report, it can't be said that MBS Stage 2, in respect of MBS Stage 2, the harm lies outside the duty. But how can we tell if particular trading losses are recoverable? I think that's where MBS Stage 5 comes to the fore. And it's going to involve the following inquiries. First, in relation to what aspects of the company's existing financial performance does the auditor's negligence relate? What should have been reported upon? In what way? And then we need to ask, what link is there between those aspects and the causes of the trading losses? It's a form of what you might call fractionation, dividing up the shortcomings of the auditor and identifying the individual reasons for the trading losses, and then seeing to what extent the fractionated pieces can be matched up. One way of putting this is to ask, has the company relied upon the auditor's approval of some particular matter in order to continue trading in a particular fashion? This process of fractionation reveals a fundamental problem with the term trading losses. It's too generic, doesn't really mean anything. To state that a company has suffered a trading loss tells us nothing beyond the end result. So instead, we need to identify why the losses have occurred. There are, of course, limitless possibilities, but just to articulate some of them, it might be that the losses result from a collusive management fraud, which should have been discovered. It might be that the losses result from inadequate stock inventory systems. It might be that the losses result from generalized business disruption due to something like COVID. And of course, there are losses resulting from a combination of factors or by concurrent factors, each operating in different periods. It seems to us that this immediately feels quite useful because it enables us to test whether the reason for the loss may be connected with the aspect of the company's existing financial situation which the auditor failed to spot. We could work it out in greater detail with some examples. Let's take some warm-up examples before moving to a harder one, which Pippa will deal with. So, as for warm-up examples, let's say that the audit client is an insurance broking practice. The auditor makes a mistake as regards the profit margin arising from premium income received from insurers. As a result, and in direct reliance on the audited accounts, premium rates in the next few years of trading are set too low, leading to loss-making trading. Now this should be recoverable because there's an exact match between the particular matter that the auditor has failed to identify and the particular fashion in which the company has traded in reliance on the clean audit report. Those were the facts of Thamesil Holdings Limited and Beaumont's Chartered Accountants, a case from 2003, where Mr. Justice Tomlinson refused to strike out the claim against the auditors, rejecting the applicability of a Galoo mere existence argument. Or we might consider a bank with a rogue employee who is placing enormous but loss-making investment trades and hiding his tracks by falsifying entries in an account identified by a Chinese lucky number. Let's say that the auditor should have discovered the false entries and thereby the loss-making trades. It would seem correct to make the auditors liable to the bank for losses it suffers as a result of further trades made by that rogue trader. Now these are the facts, of course, of Barings and Coopers and Lybrand, where Mr. Justice Evans Loam awarded damages to Barings for parts of their trading losses arising from Nick Leeson's rogue futures trading. One issue that we must grapple with in sketching out our framework, though, is as to the degree of precision necessary for a match to occur. It seems to us that the answer would be pretty precise. The essential nature of the audit failing must match the reason for the loss-making trading. So, exploring the boundaries of that, let's say Nick Leeson uses a different source of monies for his rogue trading than he had been using at the time of the audit. We don't think that should make any difference. Nick Leeson hiding his rogue futures trading in a different manner, other than in the lucky number account. I don't think that should make any difference. But what about Nick Leeson changing roles within the bank, say to deposit taking, and then stealing the monies for his own benefit? Surely the answer to that latter example is that the auditors are not responsible for this. But it does bring us to examine collective fraud cases and the need, once again, to examine more closely some well-worn terminology. I'll hand over to Pippa.
Thanks, AJ. Well, turning now to what is not an infrequent occurrence with audit negligence cases, where you have a company that has been subject to collusive and concerted fraud by its senior management. And as Jamie said, often these cases are brought by the liquidators who finally got rid of that management. And the auditor may be at fault for failing to spot that fraud and to report it at the time to the non-executive directors or the shareholders. And so let's say that the claimant company's case is that had those non-execs or shareholders learned the truth about what senior management were up to, they would have cleared out the board and put things right. For example, reaching necessary accommodations with creditors and thereafter trading profitably. But as it was, the fraudulent management remained in place and the company thereafter traded at a significant loss. And the question then is, are the losses from that loss-making trading recoverable from the company's auditor? If we apply our fractionated analysis, then the answer is yes. But it's yes, but only if the loss-making trading may be fairly said to arise from the elements of management dishonesty that the auditor should have but did not spot. But if it does, then we have a match and the damages should be recoverable. So, looking at the top line of our table, it should not be the case that if the auditor fails to spot fraud A by director A, but the losses result from fraud B by director B, the auditor would be responsible for fraud B, save unless those two frauds were sufficiently interlinked. Coming to the second line of our table, it should also not be the case that failing to spot fraud A by director A opens the auditor up to a claim for losses arising from the company being a Ponzi scheme, even if fraud A is a component of that scheme. The failure to spot that particular should not lead to responsibility for the general. And this is reiterating the point that AJ made, the need for precision as to precisely what the auditor is alleged to be at fault for, not spotting. So a blanket term such as collusive fraud is unhelpful, both when you're considering fraud at the audit stage and when you're coming on to look at what has caused the loss-making activity. In my experience, claimants are often quite imprecise about the way in which they plead this, and defendants will often need to press for better particulars or carry out their own assessment so that they can work out what the necessary elements of the fraud are and what the necessary elements of the loss-making are, so that they can see whether there's a sufficient match between the columns in the table. And coming to the third line of our table, and to take what is perhaps an unlikely set of facts, it is theoretically possible that a company's management would be involved in a collusive fraud in the sense that it thoroughly wants to mislead its auditors. The aim of its fraud is to inflate profits so as to keep shareholders and the markets happy. But as it happens, that company is not loss-making and it's otherwise being operated competently. And what happens on this hypothetical is that the subsequent loss-making arises from subsequent events, such as the impact of COVID, about which nothing could be done. And in that situation, we would suggest that there's an inadequate match between the two columns. Yes, the auditors had the wool pulled over its eyes. It's failed to spot the widespread fraud, but that is not what has resulted in the loss. And the audit fraud has no connection with the particular fashion in which the company is traded at a loss. Let's go further with another example and rejig it even more. Now the situation is, the fault of the auditor is in failing to spot widespread cooking of the books by senior management. It's told lies, it doesn't spot that. Forged documents are presented to it, it doesn't spot those. There's a thoroughly dishonest scheme which deceives the auditor. The subsequent loss-making in this instance arises from particular acts of dishonesty by the senior management team, but the auditor is not at fault for failing to identify those particular acts. Now, how do we analyse that? If you're acting for the auditor, you would obviously stress the disconnect between the fraud that you should have spotted and the fraud that has given rise to the loss-making trading. And you would resist the suggestion that a thoroughly dishonest scheme by the senior management concerning the audit process translates across to dishonest future trading. Acting for the company, though, you would, by contrast, suggest that the purpose of the audit report includes looking at whether the senior management is constitutionally untrustworthy, and any difference between the precise species of untrustworthiness is immaterial. You might argue for the claimants there that failing to spot dishonest activity by senior management is akin to a kind of hornet's nest notification. It raises considerable concerns and not simply in respect of the lies that were actually being told to the auditors. In fact, these are people that simply should not have been at the helm of that particular company. And so any losses resulting from their subsequent but different species of dishonesty should fall within the scope of the auditor's duties. Now, as AJ said, we do think this is a difficult one. And on the one hand, our analytical framework would suggest that the auditors should win the day because the two columns are not in direct correlation. But we think, as with the outcome in MBS itself, we're inclined to think that as with many instances in the law, where fraud really has a transformational effect, the winning argument would be likely to focus on that constitutional inadequacy of the management. By virtue of the auditor's negligence, the company had been deprived of the opportunity of getting rid of them. And where management's ultimately the reason as to why loss-making trading continues, we think that such losses would be recoverable from the auditor. Now, pausing there, do we have any authority to support what we're saying? And happily we do, and it's the decision of Mr. Justice Bryan in the ASIC-Co and Grant Thornton case and the Court of Appeal's decision. By quirk of timing and by way of chronology of those decisions, the Court of Appeal decision in ASIC-Co came after the Court of Appeal's decision in MBS, but before the Supreme Court's decision, so before we had our six-stage test. But it did come after the Supreme Court had done away with the strict information advice dichotomy in BPE. So the Court of Appeal's decision, we say, holds up well, notwithstanding that it has been followed by MBS and the Supreme Court. The main point before the Court of Appeal in ASIC-Co concerns the conundrum that I set out a little earlier, where you have a situation where the auditors failed to spot widespread deceit by management in the audit process, but not dishonest trading by management as such. And Lord Justice Richards addressed it in the following way. He said, "As I've indicated earlier, these submissions on behalf of GT, i.e. that they were responsible only for failing to spot audit fraud, leave out of account a major part of the case made against and accepted by GT, namely that, as at the date of the audit of the 2009 accounts, the business was ostensibly sustainable only on the basis of the dishonest representations or unreasonable decisions made and taken by management. The business was in truth not sustainable, and GT was an admitted breach of duty by not detecting the dishonest misrepresentations made to it. GT failed to detect that the senior management was deliberately concealing the true state of the business." So what the court here was doing was treating GT as having failed to draw to the non-executives or shareholders' attention that the business could only be considered to be sustainable on the basis of dishonest representations and unreasonable decisions by management. And it was not an undue stretch to say that the same dishonesty and unreasonableness was the cause of the losses in later years. And that a degree of pragmatism has entered the analytical framework is perhaps clear from what Lord Justice Richards said in an earlier paragraph of his judgment, where he stated, "It is in no sense a misuse of language to say that, where the continued operation of the business was only possible because management deceived GT into reporting as true and fair accounts which wholly misrepresented the true financial position, it was being run in a fundamentally dishonest way." So as a final point on ASIC-Co, the Court of Appeal allowed GT's appeal in one respect, as regards its responsibility for trading losses. And that was in relation to a payment that one director had received fraudulently, a £1.5 million payment pursuant to a related party transaction. And that fraud, which involved personal misappropriation, was viewed as being insufficiently connected to Grant Thornton's audit negligence. And so damages for that particular transaction were not recoverable from the auditor. So as a further practical suggestion, when you're analysing these type of claims, not only do you need to be very precise as to the audit negligence that is alleged and as to the trading losses, you need to be very precise as to different components of the trading losses, because they may not all be treated the same. So I'm now going to hand over to Jamie to consider two further aspects of trading losses before some concluding remarks.
So, what of reliance and legal causation? As to reliance, it remains a prerequisite for the claimant to prove reliance namely that the loss-making trading in the particular fashion did take place on the foundation of the clear audit opinion. And that is a question of fact. What of legal causation then? Now this brings us full circle to Galoo. As Manchester Building Society confirms at stage 6, a claimant bears the burden of proving legal causation as a separate requirement to the duty of care analyses. So it does remain necessary in trading loss claims to consider whether the audit negligence is an effective cause of any particular head of loss rather than merely the opportunity for it. Now, Mr. Justice Bryan and the Court of Appeal in AssetCo faithfully proceeded on the basis that the claimant company had to demonstrate this requirement. But we don't find it easy to discern what was left once AssetCo had succeeded on the duty of care issues and the scope of duty issues. But it does seem to us that there is a residual role for legal causation to play, and that is in 2 respects. First, let us return to the facts of Thamesil, which I'm sure you can all accurately remember. This is the insurance broking practice whose premium margin has been misstated, and that has led to loss-making trading with existing insurers of the business. Now let's say that the broking practice, believing itself to be profitable, brackets when it's not, embarks upon a program of expansion and starts to trade with new insurers. It makes the same premium margin mistake with the new insurers that it had been making with existing insurers, and so its trading losses are even greater than they were before. On these facts, we see good arguments that the auditors could argue that the audit negligence relating to the pre-existing relationship with existing insurers was only the opportunity and not the cause of the business expansion and the additional losses to which that gives rise. And secondly, it's under the heading of legal causation that it's open to auditors to argue that at some point there is a break in the chain of causation to obliterate any causal impact between the audit negligence on the one hand and the trading losses on the other. So, a summary of our framework when analysing claims against auditors for trading losses. Number 1, we do not consider that there should be or is a blanket prohibition on the recovery of trading losses. Number 2, to the contrary, a potentially wide range of trading losses are recoverable. In principle, anything which the company in general meeting could, having regard to the statutory scheme for annual accounts and audit, be expected to do on the strength of unqualified accounts. Number 3, the task is primarily one of matching the audit failure on the one hand and the particular manner of trading at a loss on the other hand. We think this is best considered as an inquiry under the Manchester Building Society duty nexus question at stage 5. Fourth, matching needs to be to a high degree of precision. Fifth, particular issues arise out of fraudulent activity by management. And as Pippa has mentioned, there is scope for pragmatism to creep in there, favouring the claimant. And sixthly, it remains for the claimants to prove reliance and legal causation. The latter will not usually require an independent inquiry, but it might do. It will do whenever the auditor suggests that there has been a break in the chain of causation. So that is our framework. You can note down on your feedback form whether you found any coherence in it. Well, I think then it leaves us to thank you for listening very patiently.